Morning.
Good morning, Mr. Cooper.
Good morning.
My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Raekwon Cooper, 402-409. Today is Tuesday, October 15th, 2024. This hearing is being conducted via video at the Board of Pardons, Parole, and Central Office and Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Raekwon Cooper, 402-409.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Attorney Alfonzo, Sirica, Public Defender with the Parole Revocation Unit, on behalf of Mr. Cooper this morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Cooper, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officers, bring against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I do not, ma'am.
You have an important right to this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. On charge 1, obedience to the law. On July 29, 2023, Connecticut State Police Troop C were dispatched to a one-car accident with possible rollover on I-84 eastbound in the town of Vernon. While Troop C was en route, dispatch advised that there was a report of an African-American male wearing black shorts and a green tank running away from the accident. Troopers confirmed upon further investigating and personal contact that you matched the individual reported to be running away down the highway. You then returned to the scene and identified yourself as Devonte Cooper. You informed the trooper your girlfriend was driving and you were at the motel during the time of the accident. The trooper instructed you to return to the motel where they could continue their investigation. When Connecticut State Police arrived at the motel, your girlfriend reported that you had left the motel and did not want to speak with troopers. It was determined through our investigation that your real name is Raekwon Cooper, date of birth 10/1/95, and you were the party driving the black SUV involved in the incident. Therefore, an arrest warrant was issued and you were arrested on March 12, 2024 for the following charges: interfering with an officer, evading responsibility, operating a motor vehicle without a license, and based on your behaviors, you are in violation of your special parole conditions, obey all laws, obedience to the law. The state has filed the following exhibits. Exhibit A, conditions of parole. Exhibit B, remand to custody. Exhibit C, parole violation report. Exhibit D, notice of parole violation. Exhibit E, Connecticut State Police Troop C police report, number ending in 600. Exhibit F, arrest warrant. Exhibit G, judicial branch conviction case detail. The state has filed an addendum to Exhibit C, which states on August 2nd, 2024, Mr. Cooper appeared in Rockville Superior Court GA 19 under docket ending in 554 and docket ending in 725. Mr. Cooper was sentenced to 6 months jail for interfering with an officer and evading responsibility. The charge of operating a motor vehicle without a license was not laid. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes. Could you please repeat the date the addendum was filed, please, for the record?
On August 2nd, 2024.
The addendum was filed on August 2nd?
That's,
I don't think that's correct.
let me look. Just 1 second, I have to open up the file.
Believe my partial.
So I stated that the state filed an addendum to Exhibit C, which states on August 2nd he appeared in court. But I'll double check the date they filed
Thank you.
the actual addendum. Oh, sorry. So on September 23rd, 2024, it was filed that on August 2nd, 2024, Mr. Cooper appeared in the Rockville Superior Court.
Correct. So the addendum was filed 9/23/24.
Is that the date you have?
Yes.
Okay. So, counsel, did you receive the notice?
Yes.
Yeah,
I
you
received
that.
that.
Okay.
Yes.
And then defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
For the first part of the hearing regarding the charges, my comments are very brief. My client still resolved the case on August 2nd of 2024. So I will concede that there was a conviction on the interfering charge and evading charge for total effective sentence of 6 months to serve. My records indicate the max court date was 9/11/24, but I have additional comments, but I think they're more appropriate for the second part of the hearing. So I anticipate you making a finding on charge 1, which I don't disagree with.
Okay. Anything further?
No, not at this point.
Okay. On charge 1, obedience to the law, I make a no finding on the charge, operation of a motor vehicle without a license, as this charge is an infraction. I make a finding on the rest of the charge based on Mr. Cooper's conviction, as well as states exhibits A, C, E, F, and G. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, regarding Mr. Cooper, I am respectfully requesting that my client be reinstated as soon as possible. I know and I realize his EOS day is coming up in December 4th of 2024 is his max date. In my humble opinion, to have my client held until December 4th of 2024 is a gross injustice for the following reasons. My client has been locked up. He was remanded on he's been locked up since August 21st of 2023. He had a previous violation where he was sanctioned to a 1-year sanction by the Board of Pardons and Parole with a re-parole date of August 22nd of 2024. This particular violation, the incident date occurred on July 29th of 2023. He was not arrested until March 12th of 2024. Ironically, coincidentally, I'm not sure which adjective is more appropriate, he was remanded on August 21st of 2024. Once again, coincidentally, ironically, is a day prior to him being re-paroled. He was supposed to be re-paroled 8/22/24 from his previous violation. This incident occurred in July 29th of 2023. Before his re-parole date, he's remanded for an incident that happened on July 29th of 2023. One. Number two, he resolved his case on August 2nd of 2024 with the disposition you put on the case. My client was scheduled for a preliminary hearing on September 10th of 2024. That preliminary hearing was canceled because there was a disposition on the case in Rockville, and so the proper parties were aware my client disposed of the case. There was an attempt to file an addendum at some point, but it was an incomplete addendum. The Connecticut State Agency's regulation 54-124 small a, small j in parentheses 1-7 clearly states that the supervising officer shall monitor the status of a criminal prosecution of each offender accused of violating a parole based upon a criminal misconduct, which is Mr. Cooper, no later than 14 business days following any new conviction. The supervising parole officer shall report to the board circumstances regarding the conviction. My client resolved the case on August 2nd. It's well past the 14 business days before this addendum was filed on September 23, 2024. Warrant is served the day prior to my client being re-paroled. There's a lot of things here that make it unjust. My client should have had his hearing at least a good month ago. He served the second violation, this one he's here for, to obedience to law. He served all that time already. Max court day on that was September 11th. Here we are, October 15th. He's finally getting his revocation hearing, and he's served day for day of that sentence. So I am asking that Mr. Cooper be re-paroled as soon as possible. I understand I'm up against the clock here, but I don't think it's fair or just to have him locked up for an additional 2 months. He's been in since August 21 of 2023. There was a conviction. He's done the time. He's done every day of this new conviction. And the sole basis for the new violation was disobedience to the law charge. My client is 29 years old. He does have one 10-year-old son who resides out of state. He is in contact with him upon his previous release to successfully complete the New Opportunities Halfway House, the Bishop House in Waterbury. And then he was sponsored by his cousin, Ms. Morales in Talker Street in New Britain. Prior to his remand, he just beginning a 12-week mechanical course at Manchester Community College. As far as work, while I was at the Bishop House, he was working full-time. He reported to us stocking at BJ's Wholesale Club in North Haven, and he was in process of transferring to the Manchester. And while he lived in New Britain, he was full-time at Pepperidge Farm in Bloomfield. And he was employed there at his time of his remand. The past year, he did report to us. He successfully completed anger management at the CRT, the Community Renewal Team in Hartford, and established primary care services at Community Health in Hartford. As far as hopefully him being reinstated to parole, he'd like to be sponsored by his mother, Ms. Williams. I provided you with her address and phone number in the document we submitted. And as a backup plan, he's amenable to being placed in a halfway house in Waterbury, his first choice for Hartford. And he does want to go back to complete the 12-week mechanical course at Manchester Community College. So I am asking to have my client reinstated for the following reasons. To keep him locked up any further is, in my opinion, and once again, nothing against you, Ms. Saunders, is just for punitive purposes at this time, given what's happened in the past year. He's done all this time in his new sentence. The sentence expired on September 11th of 2024. So I am asking that my client be reinstated as soon as possible. Thank you.
I'm gonna take a brief recess before I announce make my recommendation.
Is he muted right now?
You want to speak to him?
Yeah, but we're live streaming, right?
Mhm.
Yeah, you can keep him on.
Okay.
Thank you.
I appreciate you going to bat for me. Can't hear you. I can't hear you. Robert Famiglietti, Sonia Jones.
We are still live streaming to the public while we're in recess.
I can't hear.
I recommend revoke with no new parole date, which is an approximate 3.5 month sanction from the date of remand. While I have taken into consideration that you have been in custody since August 2023 on a prior violation, I do want to say that this is your third violation and your second criminal violation. Prior to you coming back into custody in August 2023, you were only in the community for 5 months. Now the board has the final say, so they can lower my recommendation, and your case is going to be presented on October 24th, and at that time, they can lower it. But at this time, my recommendation is no new parole date. Now, in the event that the board chooses to lessen the recommended sanction, I recommend the following conditions. Anger management and domestic violence, no contact with JW without the express permission of your parole officer, active house placement, journal no contact with KM or 45 St. John Street in Manchester, Connecticut. In addition, you are to have no contact with AW without the express permission of your parole officer, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on October 24th, 2024. Now, again, the board may lessen my recommended sanction or let my recommendation stand. Okay, so this does conclude.
I didn't even hear what you said, honestly.
Raekwon, it's gonna go, she recommended no new re-parole date, so till December, but it's going to the board on October 24th. So there's one more chance of having it reduced from your EOS date. So about a week after October 24th, you and I will get something in writing with final say. So if you want, the 24th is a Thursday, give me a call on Friday. Call the office on Friday the 25th. After 12 o'clock, I can tell you before it comes in writing what the final outcome is, okay?
Oh, so you basically recommended I just max out the special parole?
Correct.
But the board has the final decision.
I mean,
I'll talk, give me a call on the 25th. I'll speak to you on the 25th.
it's all right. It's honest, man.
Do we have Pohl?
Okay.
Good morning, Attorney Jones.
Good morning. I gotta check into that. Probably over there.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Daniel Pohl, 431-028. Today is Tuesday, October 15, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Daniel Pohl, 431-028.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Pohl.
This is a preliminary hearing which has 3 purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything that you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Pohl, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
Thank you. First, I will read your rights. Then we will review the parole violation charges that the state, your officer, is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I do not.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your officer is bringing against you. Charge 1, GPS. On August 1st, 2024, you failed to properly charge your GPS unit, causing your unit to shut down from 7:35 p.m. to 8:27 p.m. Total shutdown time was 52 minutes. On August 3rd, 2024, you failed to properly charge your GPS unit, causing your unit to shut down from 6:57 p.m. to 7:11 p.m. Total shutdown time, 14 minutes. On September 24th, 2024, you failed to properly charge your GPS unit, causing your unit to shut down from 8:19 a.m. to 10:24 p.m. Total shutdown time was 14 hours and 5 minutes. On August 2nd, 2022, you failed to properly charge your GPS unit, causing your unit to shut down from 3:09 p.m. to 6:54 p.m. Total shutdown time, 3 hours and 45 minutes. On August 11th, 2024, you failed to properly charge your GPS unit, causing your unit to shut down from 12:59 a.m. to 10:24 p.m. Total shutdown time, 21 hours and 25 minutes. On August 14th, 2024, you failed to properly charge your GPS unit, causing your unit to shut down from 8:32 a.m. to 9:46 a.m. Total shutdown time, 1 hour and 14 minutes. On August 27th, 2024, you failed to properly charge your GPS unit, causing your unit to shut down from 4:03 a.m. to 7 p.m. Total shutdown time, 14 hours and 57 minutes. On September 3rd, 2024, you failed to properly charge your GPS unit, causing your unit to shut down from 3:06 a.m. to 7 a.m. Total shutdown time, 3 hours and 54 minutes. On September 17th, 2024, you failed to properly charge your GPS unit, causing your device to shut down from 12:48 a.m. to 2:11 p.m. Total shutdown time, 13 hours and 23 minutes. On September 18th, 2024, you failed to properly charge your GPS unit, causing your device to shut down from 2:18 a.m. to 8:44 a.m. Total shutdown time, 6 hours and 26 minutes. On September 23rd, 2014, you failed to properly charge your GPS device, causing your device to shut down from 3:42 a.m. to 2:17 p.m. Total shutdown time, 10 hours and 35 minutes. On September 24th, 2024, you failed to properly charge your GPS device, causing your device to shut down from 6:01 a.m. to 8:49 a.m. Total shutdown time, 2 hours and 48 minutes. On September 25th, 2024, you failed to properly charge your GPS unit, causing your device to shut down from 7:19 a.m. to 9:07 a.m. Total shutdown time, 1 hour and 48 minutes. Your above actions are in violation of your signed GPS agreement, which states, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. On charge 2, halfway house placement. On May 9th, 2024, Fellowship Halfway House lent you the cell phone belonging to the halfway house to take with you for a job interview. Halfway house staff communicated to you that the cell phone was lent to you for the sole purpose of you being able to maintain communication with the halfway house while you were in the community, and you were instructed to return the cell phone upon your return to the halfway house. On May 14th, 2024, your roommate found the cell phone on your bed and turned it into the halfway house staff. Upon review of the cell phone records, it was discovered that you had used the cell phone for personal calls and texts after curfew hours, 10 p.m., on the night of May 9th, 2024, to the morning of May 10th, 2024. Your actions are in violation of the Fellowship House Client Handbook under telephone, which states residents' use of the telephone is restricted between 10 p.m. and 6 a.m. Exceptions to this policy will be limited to calls to work for business purposes and bona fide emergencies only. You must be approved by staff, page 10. On May 14th, 2024, you were signed out of the Fellowship Halfway House on an approved community pass to Walmart in Groton. Your pass was issued from 11:15 a.m. to 1 p.m. You failed to return to the halfway house at your scheduled return time and in the direction of Walmart. And the halfway house was unable to reach you on your cell phone. Halfway house staff then drove in the direction of Walmart in an attempt to locate you and found you in an unauthorized vehicle with a female in the parking lot of Applebee's restaurant in Groton. You returned to the halfway house approximately 1:20 p.m. You did not have permission to be at any other location other than Walmart, and you were unaccountable in the community for approximately 2 hours. Your actions are in violation of your signed halfway house agreement, which states, I will only go to the locations indicated on an approved pass unless changes have been authorized by staff. On May 22nd, 2024, when Fellowship Halfway House staff addressed you regarding you not completing your assigned house chores, you responded, my derogatory word, and you are serious. Your actions are in violation of your signed halfway house agreement, which states I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties. On May 26, 2024, you were signed out of the Fellowship Halfway House on an approved community pass to your place of employment, McDonald's, located at 561 Long Hill Road in Groton. Your pass was issued with a scheduled return time of 11:15 p.m. The halfway house contacted your employer and staff was notified that you had clocked out of your shift at 8 p.m. Halfway house and parole made attempts to contact you, but you did not respond. You returned to the halfway house at 11:15 p.m., making you unaccountable in the community for 3 hours and 15 minutes. Your actions are in violation of your signed halfway house agreement, which states I will only go to the locations indicated on approved pass unless changes have been authorized by staff. On May 27th, 2024, you were signed out of the Fellowship Halfway House on an approved community pass to your place of employment, McDonald's, located at 561 Long Hill Road in Groton. Your pass was issued with a scheduled return time of 5 p.m. You failed to return to the halfway house at your scheduled return time. Your employer was called and stated that you had clocked out and were not there. Attempts to locate you were unsuccessful. You returned to the halfway house at 11:15 and later admitted to your parole officer that you clocked out at 3 p.m. and you were with your girlfriend from 3 to 11:15 p.m. You did not have permission to be at any other locations other than McDonald's. You were unaccountable in the community for 8 hours and 15 minutes. Your actions are in violation of your signed halfway house agreement, which states I will only go to locations indicated on an approved pass unless changes have been authorized by staff, and I will return to the halfway house from community pass at my scheduled return time. On June 8th, 2024, you signed out of the Fellowship Halfway House on an approved community pass to your employer, McDonald's, located at 561 Long Hill Road in Groton, and you only had permission to be at that location. A review of your GPS indicated that you left McDonald's and went to Walmart in Groton for approximately 15 to 30 minutes between the hours of 6 to 7 p.m. without permission from the halfway house or your parole officer. Your actions are in violation of your signed halfway house agreement, which states I will only go to the locations indicated on an approved pass unless changes have been authorized by staff. On June 24th, 2024, you signed out of the Fellowship Halfway House on an approved community pass to your place of employment, McDonald's, located at 561 Long Hill Road in Groton, and you only had permission to be at that location. A review of your GPS indicated that you left McDonald's and went to an apartment complex in Groton for approximately 15 to 30 minutes between the hours of 7 and 8 p.m. without permission from the halfway house or your parole officer. Your actions are in violation of your signed halfway house agreement, which states I will only go to the locations indicated on an approved pass unless changes have been authorized by staff. On September 14th, 2024, you were signed out of the Eddy Center Halfway House on an employment pass to Connecticut Rental Center in Middletown. Your pass was issued from 7:15 a.m. to 4:30 p.m. At approximately 11:05, halfway house staff conducted an accountability check for you at Connecticut Rental Center, and they were informed by your employer that you had not shown up for work that day. Attempts made to locate you via your cell phone and other collateral contact were unsuccessful. You subsequently returned to the halfway house at 3:37 p.m. and stated that you were at the park with your girlfriend. You were unaccountable in the community for approximately 8 hours and 8.25 hours. Your actions are in violation of your signed halfway house agreement, which states I will only go to the location indicated on an approved pass unless changes have been authorized by staff. On September 24th, 2024, this PO conducted a routine tour of Eddy Center Halfway House. Upon arriving to your assigned room, this PO noticed the smell of marijuana. You were the only person in the room at the time. A pat search of your person was conducted, and you were found in possession of 2 cell phones. A search of your room was then conducted for a third cell phone, multiple vapes, a vape phone, and rolling papers were found amongst your property. Your actions are in violation of the Eddy Center Resident Handbook, which identifies these items as contraband and prohibits your possession of them in the halfway house. You are also in violation of your signed residential program, Offender Electronic Device Disclosure Form Term 12. I will only possess one cell phone, which shall remain registered with the program. On September 26, 2024, while you were being transported to Hartford Correctional Center, following your remand from the Eddy Center halfway house, you admitted to your parole officer that you had marijuana hidden in your pants. Their marijuana was subsequently found on your person. Your actions are in violation of your signed halfway house agreement, which states I will not consume or possess alcohol or marijuana in the halfway house. The state has filed the following exhibits. Exhibit A, remand to actual custody order. Exhibit B, signed PCS conditions. Exhibit C, notice of parole violation and parolee rights. Exhibit D, parole violation report. Exhibit E, halfway house agreement. Exhibit F, GPS agreement. Exhibit G, fellowship house incident report dated 5/14/24. Exhibit H, fellowship house residential discipline report. Exhibit I, offender misconduct report. Exhibit J, fellowship house incident report. Exhibit K, fellowship house residential discipline report. Exhibit L, offender misconduct report. Exhibit M, fellowship house incident report. Exhibit M, fellowship house incident report. Exhibit N, fellowship house residential discipline report. Exhibit O, offender misconduct report. Exhibit P, fellowship house incident report. Exhibit Q, fellowship house residential discipline report. Exhibit R, offender misconduct report. Exhibit S, offender misconduct report. Exhibit T, Allied Universal GPS position history. Exhibit U, offender misconduct report. Exhibit V, Allied Universal event history. Exhibit W, offender misconduct report. Exhibit X, Allied Universal event history. Exhibit Y, offender misconduct report. Exhibit Z, Allied Universal event history. Exhibit AA, offender misconduct report. Exhibit BB, Eddy Center incident report. Exhibit CC, Eddy Center residential discipline report. Exhibit DD, offender misconduct report. Exhibit EE, Allied Universal event history. Exhibit FF, offender misconduct report. Exhibit GG, Allied Universal event history. Exhibit HH, offender misconduct report. Exhibit II, contraband picture take at halfway house. Exhibit JJ, offender misconduct report. Exhibit KK, Allied Universal event history. Exhibit LL, offender misconduct report. Exhibit MN, fellowship house client handbook and signed handbook consent form. Exhibit NN, signed Eddy Center resident handbook acknowledgement form and contraband list. Exhibit OO, CTDOC residential program offender electronic device disclosure form. Exhibit PP, confiscated marijuana picture. And Exhibit QQ, BOPP revocation summary, hearing summary. Counsel, did you receive the notice of parole violation report, and other documents that were just marked for identification purposes?
Yes, I did.
Today, we have no witnesses, and it is now the defense's opportunity to respond and make a short statement and testify with respect to probable cause and the severity of the allegations.
Thank you. In regards to charge 1, GPS under release direction, addressing the paragraph that indicates on August 7th of 2022, we would just submit that there's insufficient evidence to support that charge, as there's no evidence submitted that my client was in violation on August 2nd of 2022. In regards to the paragraph beginning on September 23rd of 2014, again, we would submit there's insufficient evidence to support this charge, as there's no evidence to support my client was in violation on that particular date. And then addressing charge 2, halfway house placement, as well as charge 1, I would just note that under the graduated interventions and sanctions section, it does appear as though my client was given sanctions for some of this alleged conduct, and that those sanctions were successfully served. Based on that, we would submit that this is not serious enough to warrant further detention. My client was gainfully employed, working in both the Groton area as well as the Middletown area. He was employed at the time of his remand. I don't have any reason to believe that he wasn't successful with programming. He had attended an intake at AIC, however, was not able to begin that programming yet because of the remand. He's 23 years of age. He's a high school graduate. He does have some college at Three Rivers that he successfully completed. Based on all of those things, we would submit that it's not serious enough to warrant further detention. Thank you.
Okay, thank you. I'm just going to take a moment while I review, before I make my findings and review the evidence I was just provided. On charge 1, GPS, I make a no finding on parts 4 and 11 as the state failed to provide sufficient evidence to prove that Mr. Pohl's actions meet the elements of this charge. I make a finding of probable cause on the rest of the charge based off of state's exhibits B, F, V, W through Z, AA, EE, FF, GG, HH, KK, and LL. On charge 2, halfway house placement, I make a no finding on part 10 as the state failed to provide sufficient evidence to prove that Mr. Pohl's actions meet the elements of this charge. I make a finding of probable cause on the rest of the parts listed in this charge based on state's exhibits B, E, G through S, U, BB, CC, DD, JJ, MM, and OO. I find that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you wait your revocation hearing. Your revocation hearing will be scheduled within 60 business days from the date of your return to custody. You will receive a hearing disposition, which will have a tentative hearing date listed, as all hearing dates are subject to change. At the revocation hearing, a hearing officer will determine if you violated the conditions of your parole. If so, the hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. So this does complete your preliminary hearing.
May I just inquire, paragraph 10 of charge 2, is that the paragraph beginning on September 24th of 24?
On September 26, 24, the very last paragraph.
All right, thank you.
And Mr. Pohl, you're all set. Oh, go ahead, Attorney Jones.
Daniel, I will be reaching back out to you, okay?
All right, thank you.
You're welcome.
Yeah.
Thank you.
You have Mr. Cruz?
All right. Bruce.
Okay. How you doing? No. You hear me?
We can
Oh,
hear
no.
you, sir, but the room is muted until the officer returns.
All right, thank you.
Good morning, Louis Cruz. Morning. So good morning. You want me to talk about the attorney or you go ahead? I mean, at the
Sir, this is your attorney, Rob Famiglietti. Do you understand English?
Yeah.
Do you need an interpreter?
Yeah, still.
You do need an interpreter, or do you want us to proceed in English? Do you speak English?
I do, but at the same time, I want to understand you right what they're saying, the explanation of everything. You understand what I'm saying?
No, I don't. Would you like an interpreter for the proceedings?
Yes.
Okay.
Would you feel comfortable, and it's up to you and your attorney, to, if you don't understand something, we can have the interpreter say it in Spanish to you? Would you like that, or you would like everything in Spanish?
Spanish.
Okay. Ms. Liza Rivera, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that you will faithfully discharge, according to law, your duties as an interpreter to your best abilities, so help you God, or upon penalty of perjury? I do. Thank you. Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Louis Cruz, 241234. Today is Tuesday, October 15th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution.
Buenos días, soy la oficial Saunders, examinadora de la Junta de la Audiencia para la Junta de Indultos y Libertad Condicional de Connecticut. Esta es una audiencia preliminar en referencia a Louis Cruz, número 241234. Hoy es martes 15 de octubre del 2024. Esta audiencia está siendo conducida vía video a la Oficina Central de la Junta de Indultos y Libertad Condicional y la Institución Correccional de Carl Robinson.
Please state your full name and DOC inmate number for the record.
Por favor, decir su nombre completo y número de confinado de DOC para el registro.
Luis Alberto Cruz, 241234.
Louis Cruz, 241234.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Public Defender Robert Famiglietti of the Parole Revocation Unit.
Esta es una audiencia pública. Acceso público a esta audiencia está disponible vía transmisión en vivo. También presente esta mañana está el señor abogado Famiglietti de la Unidad de Revocación de Libertad Condicional en su defensa.
This is a preliminary hearing which has three purposes under Connecticut law. To determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything that you say at this hearing can be used against you. This hearing is being recorded.
Esta es una audiencia preliminar, la cual tiene tres propósitos bajo la ley de Connecticut.
para determinar si hay causa probable para creer que usted cometió un acto que violó las condiciones de su libertad condicional, determinar si el acto es suficientemente serio que garantiza la revocación de su libertad condicional, para determinar si usted debe ser revocado, debe ser detenido en prisión pendiente a procedimientos adicionales. El Estado, no usted, tiene la responsabilidad de demostrar que hay causa probable para creer que usted violó una o más de las condiciones de su libertad condicional. Si yo no encuentro causa probable, restableceré su libertad condicional, lo que significa liberarlo y colocarlo de nuevo bajo supervisión. Si encuentro causa probable y determino que el acto es suficientemente serio para justificar una revocación, usted podría ser detenido en prisión pendiente a procedimientos adicionales. Usted debe saber que una audiencia preliminar es un procedimiento adversarial. Cualquier cosa que usted diga en esta audiencia puede ser usada en su contra. Esta audiencia está siendo grabada.
The testimony at today's hearing will be taken under oath. Mr. Cruz, please raise your right hand.
El testimonio del día de hoy será tomado bajo juramento. Mr. Cruz, favor levantar su mano derecha.
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Usted jura solemnemente o afirma, según sea el caso, que la evidencia que usted dará sobre este caso será la verdad, toda la verdad y nada más que la verdad, que así lo ayude Dios o bajo penalidad de perjurio.
Thank you. First, I will read you your rights. Then we will review the parole violation charges of the state your officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
Le voy a explicar el procedimiento de la audiencia. Primero leeré sus derechos, luego revisaremos los cargos de violación de libertad condicional que el Estado o su oficial de supervisión está presentando en su contra. Luego revisaré e identificaré las pruebas presentadas para el registro. La defensa tendrá la oportunidad de abordar el tema de causa probable y la severidad de las alegaciones. Al concluir esta audiencia, anunciaré mis hallazgos, los cuales serán basados en la evidencia presentada. ¿Tiene alguna pregunta sobre el propósito antes de comenzar?
No.
You have important rights at this hearing, which I will now review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Le estaré leyendo los derechos en el día de hoy. Usted tiene el derecho a ser representado por un abogado en esta audiencia, el cual usted ha ejercido en el día de hoy. Usted tiene el derecho a recibir notificación por escrito de los cargos de la violación. Usted tiene el derecho de revisar la evidencia en su contra antes de esta audiencia. Usted tiene el derecho de someter evidencia para apoyar su caso. En esta audiencia usted tiene el derecho de interrogar testigos voluntarios, como también interrogar testigos adversos. ¿Entiende usted estos derechos?
Sí.
We now will review the charges that the state your officer is bringing against you and the information underlying each charge. On charge 1, obedience to the law. On September 25th, 2024, at approximately 12:19 a.m., Hartford Police Department responded to Stain Halfway House due to your involvement in a physical altercation with your roommate. You reportedly struck him in the face with a closed fist at least 4 to 5 times. Subsequently, you were arrested and charged with assault third and disorderly conduct. You were arraigned on September 25th, 2024, under docket ending in 505, and given a promise to appear with a next court date of November 13th, 2024. Charge 2, drugs. On September 25th, 2024, you admitted to smoking crack on September 23rd, 2024. This is a violation of your condition of drugs, as it at no time are you supposed to use, be in control of, or possess any legal substances.
Pero voy a estar leyendo los cargos que su oficial ha presentado en su contra. Cargo número 1, obediencia a la ley. El 25 de septiembre del 2024, aproximadamente a las 12:19 de la madrugada, el Departamento de Policía de Hartford respondió al Stain Halfway House debido a su envolvimiento en un altercado físico con su compañero de cuarto. Según se informa, usted golpeó a la víctima en la cara con el puño cerrado al menos en 4 o 5 ocasiones. Subsecuentemente, usted fue arrestado y acusado de agresión en tercer grado y conducta desordenada. Usted fue procesado el 25 de septiembre del 2024 bajo el expediente que culmina en 505 con una promesa a comparecer y una nueva fecha de corte del 13 de noviembre del 2024. En el cargo número 2, drogas, el 25 de septiembre del 2024 usted admitió fumar crack. Esta es una violación de su condición de drogas, ya que en ningún momento usted está supuesto a usar, estar en control o poseer algún tipo de sustancias ilegales.
The state has filed the following exhibits. Exhibit A, remand to custody order. Exhibit B, parole conditions. Exhibit C, parole violation notice. Exhibit D, parole violation report. Exhibit E, Hartford Police Report, case number ending in 922. Exhibit F, photos. And Exhibit G, voluntary admission of use.
El Estado ha presentado las siguientes pruebas como propósito de identificación: evidencia A, orden de regreso a custodia; B, condiciones de libertad condicional; C, aviso de violación a libertad condicional; D, reporte de violación a libertad condicional; E, reporte de policía de Hartford, número de caso que termina en 922; F, fotos; G, admisión voluntaria de uso.
The state has filed an addendum to Exhibit D, which states on October 2nd, 2024, the charges of assault third and disorderly conduct were nollied. Counsel, did you receive the notice of parole violation report, and the other documents I just marked for identification purposes?
Yes.
El Estado también recibió el siguiente anexo. El 2 de octubre del 2024, los cargos de agresión en tercer grado en conducta desordenada fueron eliminados con un noli o nulo.
Today, we have no witnesses, and it is now the defense opportunity to respond, make a short statement, and testify with respect to probable cause and the severity of the allegations.
No tenemos testigos en el día de hoy. Esta es la oportunidad de la defensa de hablar en relación a el testimonio del día de hoy.
Yes, as to charge 2, there were no testing, no chemical analysis, merely an admission. As to charge 1, the charges were nollied. They were pursued in community court, and both charges were nollied based upon the fact that the state believed they couldn't support a prosecution. So I don't believe there's probable cause for charge 1 or charge 2. Thank you.
En el cargo número 1 no hubo ningún tipo de prueba, tampoco hubo ningún tipo de análisis químico, solamente un formulario de admisión voluntaria. En el cargo número 2, ambos cargos fueron anulados o noli, ya que la Policía Estatal de Connecticut no pudo acusarlo en ese caso, por lo tanto entiendo que ese cargo no puede proceder.
Lastly, as to the seriousness of the allegations have to be sufficiently serious to go forward. Even if a finding is made on both charges, we have a nollie of the criminal allegations against him, and we have 1 admitted use of crack cocaine. When was he paroled again? July 8th,
2024.
Okay, so we're only talking about 1 positive test that I believe there's possibly probable cause for. That's no reason to incarcerate him any further. He's been held since September 25th. I don't believe jail is a requirement. I believe he should be immediately released to supervision of parole, as the nature of these violations is not serious enough to warrant further incarceration.
Entiendo que en el cargo número 1 no hay una suficiente seriedad, ya que estos cargos fueron anulados y no pudieron proceder con los cargos criminales en su contra. En el cargo número 1 solamente tenemos una admisión voluntaria, solamente en una ocasión, y un resultado positivo. Mi cliente lleva encarcelado desde el 25 de septiembre. Entiendo que no es necesario más tiempo en prisión y que él debe ser puesto en libertad inmediatamente, ya que estos cargos no son lo suficientemente serios.
On charge 1, obedience to the law, I make a finding of probable cause based on state's exhibits B, D, and E. On charge 2, drugs, I make a finding of probable cause based on state's exhibits B, D, and G.
En el cargo número 1 hago un hallazgo en la condición de obediencia a la ley basado en la evidencia del Estado B, D y E. En el cargo número 2, drogas, hago un hallazgo de causa probable basado en la evidencia presentada por el Estado B, D y G.
Being that Mr. Cruz was released on July 8, 2024, and was remanded on September 25th, 2024, which is he was in the community for approximately 2.5 months, where he was arrested and admitted to crack use. I do find that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you wait your revocation hearing.
Mr. Cruz fue puesto en libertad previamente en julio del 2024 y fue regresado a prisión en septiembre del 2024, lo que fue un periodo aproximado de 2 meses y medio en la comunidad antes de ser arrestado y haber admitido el uso de crack. Entiendo que estos cargos son lo suficientemente serios para garantizar una revocación.
Your revocation hearing will be scheduled within 60 business days from your return to custody. You will receive a hearing disposition which will have a tentative hearing date listed, as all hearing dates are subject to change. At the revocation hearing, a hearing examiner will determine if you violated the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what, if any, sanctions should be imposed. This concludes the preliminary hearing.
La audiencia de revocación será programada dentro de 60 días laborables de su regreso a custodia. Usted recibirá una disposición de esta audiencia, la cual tendrá una fecha tentativa establecida, ya que las fechas son sujetas a cambio. La audiencia de revocación, yo u otro examinador de audiencia determinará si usted violó las condiciones de su libertad condicional. De ser así, el examinador de audiencia hará recomendaciones con respecto a si su libertad condicional debe ser revocada y qué sanciones debe ser impuestas.
So, sir, they made a finding that you used drugs and that there was an incident that occurred at the halfway house, even though the case was dropped in court. So we'll have another hearing within the next 60 days. Okay, sir?
Yep.
Okay.
Thank you.
Thank you very much, sir.
Yep.
One here.
Hi, do you have Mr. Hosendove?
Okay, man. Come on, Representative. You can have that. This one is like. Thank you.
I know.
Good morning. How do you pronounce your name?
Jamal Hosendove.
Hosendove. Okay. Well, good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jamal Hosendove, 299904. Today is Tuesday, October 15th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC number for the record.
Jamal Hosendove, 299904.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Attorney Robert Famiglietti of the Public Defender's Parole Revocation Unit. Hello, sir.
Hello, sir. How you doing? Good morning.
Good. How are you? Good morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there's preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Hosendove, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you. First, I will review your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, obedience to the law. On August 13th, 2014, while Parole was conducting an unannounced compliance check in collaboration with with Connecticut DOC K-9 unit, a K-9 officer located a large amount of marijuana stuffed into a tall coffee cup inside of a vitamin container and also inside of a soap holder, which were all located next to a divider in the cafeteria. Upon review of the security system, it was discovered that you were the one who tossed the marijuana into the corner of the cafeteria upon Parole's arrival to the halfway house. Upon questioning, you admitted that the marijuana in question was in fact yours. As a result, Troop H was called in to investigate this matter, and you were subsequently arrested and charged with possession of a controlled substance first offense. Based on your behavior, you are in clear and direct violation of your signed parole conditions, specifically under OBL laws, as you engage in an act which is a crime. Charge 2, halfway house placement. On August 13th, 2024, while Parole was conducting an unannounced compliance check in collaboration with a CT DOC K-9 unit, the K-9 officer located a large amount of marijuana stuffed into a tall coffee cup inside of a vitamin container and also inside of a soap holder, which were all located next to a divider in the cafeteria. Upon review of the security system, it was discovered that you were the one who tossed the marijuana into the corner of the cafeteria upon Parole's arrival to the halfway house. Based on your behavior, this places you in clear violation of your signed parole conditions, specifically under halfway house placement, as you violated a rule in your signed halfway house agreement where it states, I will not possess or consume alcohol or marijuana in the halfway house. The state has filed the following exhibits. Exhibit A, PCF signed conditions. Exhibit B, halfway house agreement. Exhibit C, open hearth halfway house incident report. Exhibit D, marijuana photos ×2. Exhibit E, video evidence. Exhibit F, copy of summons. Exhibit G, Connecticut State Police report. Exhibit H, Connecticut Judicial Branch pending case detail. Exhibit I, remand to custody order. Exhibit J, violation of parole or notice of parole violation. Exhibit K, parolee rights. And Exhibit L, parole violation report. The state has found an addendum to Exhibit L, which states on September 13th, 2024, Mr. Hosendove pled guilty possession of controlled substance first offense and was sentenced to unconditional discharge under docket ending in 671. Counsel, did you receive the notice of parole violation report, and the other documents that I just marked for identification purposes?
Yes, I.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
I have no comment as to the components of the evidence standard.
On charge 1, obedience to the law, I make a finding based off Mr. Hosendove's conviction, as well as states exhibits A, C, F, G, H, and L. On charge 2, halfway house placement, I make a finding based on states exhibits A, B, C, F, G, and L. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, my client's been held for just over 2 months. He received an unconditional discharge for possession of marijuana. He was fully cooperative with the police and the halfway house personnel. This is his first violation. He received no misconducts or graduated sanctions. His parole officer is leaving it up to the board. This is a nonviolent offense. Were it a smaller amount of marijuana, he would have been arrested only because he had it in the halfway house. Marijuana is now legal at certain amounts. He's single. He's 43 years of age. His support system is large. His family, his friends, his sister, aunt, various cousins. He has 2 children, ages 26 and 13, who reside in North Carolina. He interviewed with a school program to return to obtain his GED while he was at Open Hearth. He's worked in the past at Demers Exposition Services. He applied to Sardilli Produce, Bear Smokehouse. He was in the process of being hired by Bear Smokehouse. He participated in CBT groups at Community Renewal Team. He suffers from asthma. He's medication compliant. Upon reinstatement of parole, he'd like to be placed in a halfway house in Hartford. And he was in the process previously of establishing services. He wishes to obtain his GED, wishes to get involved with the real estate industry. He enjoys drawing and wishes to attend an art class. He can return to Denver's Exposition Service in East Hartford and or start at Bear Smokehouse. As I stated earlier, we don't believe this is a sufficiently serious I know that's a preponderance standards, and I know this isn't a preliminary, but I don't believe this is a serious violation of parole. It's his first violation. He served 2 months, and I'd ask that he be released at the next possible date. Thank you very much for your time and consideration.
I'm going to take a moment before I announce my recommendation. Okay. I recommend revoke and re-parole on October 24th, 2024, which is an approximate 2.5-month sanction. I recommend the following conditions: no consumption of alcohol, no contact with victims MC, halfway house placement, general no contact with TF, mental health treatment. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on October 24th, 2024. The board may let my recommended sanction stand or impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be held. Before the hearing, the board will provide you with written notice documenting the reasons why they might want to exceed my recommendation. During the supplemental hearing, you will have an opportunity to respond to those specific reasons while in front of a panel of the board. So that does conclude the revocation hearing. So,
All right,
do you have any questions? Do you have any questions?
You said to the 24th, so I'll be seen again?
No, that's my recommendation for you to be re-paroled, but the board will rehear, they're going to hear your case, they're going to review your case and make the final decision on the 24th. So if they agree with my decision of releasing you on October 24th, then you would be released on that day. If not, then we would have an additional hearing.
All right, thank you.
Actually have discretionary parole, is it? Are you on discretionary parole, sir, or special parole?
I'm on parole just until my EOS, so I think it's discretionary.
So your release date is an on or after day. So they may or may not release, if they decide to release you on the 24th, it's an on or after day. So it may not be exactly the 24th. It might be a few days or so after, okay? Because it's discretionary parole. Okay, sir?
All right.
All right.
Thank you.
Call us on the 25th and we'll let you know what happened. Hopefully you'll be released.
All right, thank you.
Take care.
All right. Okay.
Do you have Mr. Rodriguez?
Not yet. He's not here yet.
Okay, thank you. Hello.
Hi, so I'm looking at my list, but I don't have a Rodriguez.
He was just transferred to you guys, let me say, at the end of last week. I could give you his inmate number.
Yeah, I have to call for them to get him. Okay,
341008.
341008, and that's Rodriguez.
Yep, Felix Rodriguez.
Okay. All right, thank you.
Thank you.
Done.
I got it. He's at Osborn. He's not with you guys. Thank you.
Are you doing the other guys also?
Yeah, that's what Officer Trusello, she should be calling literally in the next few minutes.
Okay, great. Thank you.
Thank you. Good morning.
Hi, good morning. How are you?
But I don't know if you have Mr. Rodriguez on your docket for today. He was just transferred to you guys.
Let me check. Hold on. Is it the one from MacDougall?
Yes.
Yes,
341008.
correct.
So I don't have him. He's on my docket, but it says MacDougall. I could call so I could see if I can get him here while you're
Perfect.
still
Then we
on.
can start with Sanders if he when he gets there, if he's available.
Sanders not here yet, but I have Gaffney.
Okay, so then I'll start with Gaffney.
Okay.
And then once Sanders or whoever comes first, it doesn't matter.
Okay, I'll try
Thank
and
you.
call for Rodriguez now.
Okay, sounds good. Thank you.
Thank you. Okay, Gaffney, come on in. I have you in this room here.
morning, Mr. Gaffney.
Good morning.
We're gonna get started in a few minutes, okay?
Okay.
Thank you.
Mhm.
Yeah, he asked you about it? Yeah. Okay, so they just called me and told me that we. Yeah. Four, 6, 5, 6. Yeah, 4, 6, 5, 6. What's the number? Oh, that's on the parole loan. 6, 5, 6.
All right, good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Thomas Gaffney, 319-605. Today is Tuesday, October 15th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Thomas Gaffney, 319-605.
This is a public hearing. Public access to this hearing is available via video live stream. This is a preliminary hearing which has 3 purposes under Connecticut law. To determine if there is probable cause to believe that you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything that you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Gaffney, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your officer is bringing against you. Then I will review and identify exhibits sought for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You may hire your own attorney. If you cannot afford an attorney, you may be qualified for an appointed attorney to represent you. Do you intend to seek counsel for this hearing or proceed without?
Proceed without.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross adverse witnesses. Do you understand these rights?
Yes, I do.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. On charge 1, program participation, on September 23rd, 2024, you were placed in the inpatient program. On September 27th, 2024, you jumped the fence at the program and subsequently absconded from the program. You were negatively discharged from the program. Charge 2, residence. You were unsuccessfully discharged from level substance abuse treatment. So that's part of charge 1. So charge 1 is program participation, and you were unsuccessfully discharged from Wellmore substance abuse treatment due to continued use of cocaine. Charge 2, residence. On September 23rd, 2024, you were placed in the App Foundation inpatient program. On September 27th, 2024, you jumped the fence at the program and subsequently absconded from the program. Charge 3, absconder. On September 23rd, 2024, you were placed in the App inpatient program. On September 27th, 2024, you jumped the fence at the program and subsequently absconded from the program. This appeal attempted to contact you via your cell phone and also contacted your sponsor, and your whereabouts were unknown at that time. Charge 4, drugs. On July 12th, 2024, you admitted to using cocaine and signed a voluntary drug admission form. On August 15th, 2024, you admitted to using cocaine and signed a voluntary drug admission form. On September 20th, 2024, you admitted to using cocaine and signed a voluntary drug admission form. The state has filed the following exhibits. Exhibit A, remand to custody. Exhibit B, special parole conditions. Exhibit C, remand to custody. Exhibit D, parole violation report. Exhibit E, notice of parole violation. Exhibit F, signed voluntary drug admission forms. Exhibit G, apt unsuccessful discharge letter. Exhibit H, Wellmore unsuccessful discharge letter. Mr. Gaffney, did you receive the notice of parole violation report, and the other documents that I just marked for identification purposes?
Yes.
Today we have no witnesses. It is now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time?
Yeah, I just want to say I didn't jump a fence. I walked through the fence.
Anything else?
No, that's it.
Okay. On charge 1, program participation, I make a finding of probable cause based on state's exhibits B, D, G, and H. On charge 2, residence, I make a finding of probable cause based on state's exhibits B, D, and G. On charge 3, absconder, I make a finding of probable cause based on state's exhibits B, D, and G. On charge 4, drugs, I make a finding of probable cause based on state's exhibits B, D, and F. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait your revocation hearing. The Department of Correction has recommended you for diversion from the revocation process for substance abuse programming and treatment, the TOP program. This means that if you wish to participate and apply, I find that you meet certain eligibility criteria, I can continue your case while you are provided an opportunity to participate in substance abuse programs and treatment in the correctional facility. If you successfully complete the program and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the program and treatment provided, the board will schedule and convene a revocation hearing to determine if you violated the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what, if any, sanctions should be imposed. The decision to participate in diversion is voluntary. Do you understand the diversion process, and do you wish to apply for diversion, which is the top program?
Yeah, I want the top program, please.
I will announce my findings with respect to your eligibility. If I determine that you are eligible, I can accept your application and divert you from revocation. I have reviewed all relevant information, and my findings are as follows. I find that you have no pending misdemeanor or felony charges. I find that your discharge date is more than 60 business days from the date of remand. I find that there is evidence that you have identified substance abuse treatment needs. I find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with the terms and conditions of your parole. And I find that there is some evidence that you received or were provided with an opportunity to receive substance abuse programming or treatment during your period of parole supervision in the community. I have determined that you are eligible for diversion for substance abuse programming and treatment. Before I accept your application for diversion, I ask that you indicate whether you understand the following by answering yes or no. I understand that I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result.
Yes.
I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse programming and treatment.
Yes.
I understand that ultimately the Department of Correction will determine whether I have successfully completed the substance abuse programming and treatment provided.
Yes.
I understand that my participation in this process is completely voluntary.
Yes.
Your application for diversion is granted. You will be placed in a treatment or programming by the Department of Correction and diverted from revocation for no more than 60 business days. Okay, so now you will be, I don't know if you're already in top, but you should be placed in top very shortly. And now this does conclude your preliminary hearing.
Thank you.
Thank you. You're all set.
Thank you.
You're welcome. I have Rodriguez here, okay?
Okay, we'll get started with Mr. Rodriguez. Thank you.
Okay, come on in, you're welcome. Yeah. You have to sit in here though.
Yeah, I'm gonna sit. Sorry about that.
Good morning, Mr. Rodriguez.
Morning, Corey.
I'm going to just grab your attorney. Okay, so just give me one moment.
Okay.
Okay.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Felix Rodriguez, 341008. Today is Tuesday, October 15th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Felix Rodriguez, 341008.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Public Defender Robert Famiglietti of the Parole Revocation Unit. Good morning, sir.
Good morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be forwarded to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony of today's hearing will be taken under oath. Mr. Rodriguez, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. On charge 1, reporting. On December 5th, 2022, you left the New Haven parole office without permission. Your supervising officer sent you a text message and left a voice message instructing you to return to the New Haven office. You failed to return as instructed. To date, you have failed to make contact with your parole officer or report to the New Haven office. Charge 2, GPS. From November 16th, 2022 to November 21st, 2022, and on November 29th, 2022, you failed to stay at your parole-approved residence at 25 Reed Street in New Haven. You failed to abide by numbers 5 and 11 of the GPS monitoring agreement. On December 5th, 2022, you removed the GPS device from your person. You failed to abide by numbers 1 through 3 of the GPS monitoring agreement. You signed the agreement on August 19th, 2022. Charge 3, residence. On dates November 16th, 2022 to November 21st, 2022 and November 29th, 2022, you failed to reside at your parole-approved residence of 25 Reed Street, New Haven, Connecticut. From December 5th, 2022 to date, you have failed to return to your parole-approved residence of 25 Reed Street, New Haven, Connecticut. You were not given permission to reside at any other addresses in the community by your supervising officer. Charge 4, absconder. On December 5th, 2022, you reported to the New Haven District Office. You were informed by this officer that you have been referred to Walter Brooks Halfway House and that this officer would be transporting you. You walked out of the lobby, proceeded to get in a vehicle and drive off. You were called on your cell phone went directly to voicemail where this PO left a message instructing you to return to New Haven Parole Office. You were also sent a text message via text instructing you to return to the New Haven Parole Office. You failed to respond. To date, your whereabouts in the community remain unknown. Obey all laws. Charge 5. On charge 1 of obey all laws under obedience to the law, on January 4th, 2023, you were arrested by Derby Police. Concurrent charges are criminal possession of a firearm, carrying a pistol without permit. You failed to appear for your court date on this matter, and a rearrest was ordered on January 6, 2023, under docket ending in 473. Based on your behaviors, you are in violation of your parole condition. Obey all laws. Will obey all laws. Charge 2, under obedience to the law. On January 4th, 2023, you were arrested by Bridgeport Police. Current charges are interfering with officer and resisting, disorderly conduct, reckless driving, evading responsibility. You were issued a promise to appear with a court date of January 5th, 2023 at GA 2 Bridgeport. You failed to appear, and a rearrest was ordered on January 6th, 2023 under docket numbers ending in 918 and 825. Based on your behaviors, you are in violation of your parole condition. Obey all laws. Will obey all laws. Charge 3, under obedience to the law. You currently have an active arrest warrant having been prepared and filed by Derby Police regarding case number ending in 105. Current charges are escape from custody, assault of a police officer, larceny 6. Based on your behaviors, you are in violation of your parole condition. Obey all laws. Will obey all laws. And charge 6, drugs. On November 22nd, 2022, you rendered a urinalysis that was positive for PCP. You signed a voluntary admission. Per your conditions, you are not to use, have in your possession, or control any illegal drug or narcotic. The state has filed the following exhibits. Exhibit A, Connecticut Conditions of Parole / GPS Monitoring Agreement. Exhibit B, Connecticut Board of Parole Remand to Custody. Exhibit C, Notice of Parole Violation and Parolee Rights. Exhibit D, Parole Violation Report. Exhibit E, Offender Misconducts. Exhibit F, Voluntary Admission. Exhibit G, Affinity Event History. Exhibit H, Derby Police Report ending in 076. Exhibit I, Bridgeport Police Report ending in 851. Exhibit J, Derby Police Report ending in 105. Exhibit K, signed Derby Police Arrest Warrant case ending in 105. Exhibit L, State of Connecticut Judicial Branch pending case detail, docket ending in 473. And State of Connecticut Judicial Branch pending case detail regarding docket numbers ending in 918 and 825. The state has filed an addendum to Exhibit D, which states the charges of criminal possession of a firearm and carrying a pistol without permit was sub to 2 counts of harassment second. Mr. Rodriguez received a guilty sentence of conditional discharge for the 2 counts of harassment second, ending in docket 473. Mr. Rodriguez was also found guilty of escape from custody and assault of a police officer. He was sentenced to 10 years jail, execution suspended after 2 years, followed by 4 years probation under docket ending in 729. Regarding dockets ending in 825 and 918, the following charges were dismissed: reckless driving, evading responsibility, disorderly conduct, larceny 6, and interfering with an officer. Counsel, did you receive the notice of parole violation report, and the other documents that I just marked for identification purposes?
Yes, I have.
Defense has filed the following exhibits. Exhibit 1, parole accomplishments and future plans for parole reinstatement. Exhibit 2, DOC captain letter of support. And Exhibit 3, certificate of completion. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Yes, that's the charge one. I don't believe it meets preponderance standard. The defendant actually did report. They're saying he left without permission. There's no proof that he received notice to come back after he already had reported to parole. I've got no comment as to charge 2. As to charge 3, there's no evidence that he actually changed his residence. He may not have stayed at those places for that particular time if there's proof of that. However, that does not meet the requirement that there's proof that he actually moved somewhere else. No comment as to charge 4. As to charge 5, the charges were subbed in reviewing the transcript because there was absolutely no evidence of any handgun ever being used or displayed. It was subbed to a harassment as a plea negotiation. I just wanted to correct for part 3. He was sentenced to 10 after 2, 5 years probation, not 4 years probation. And I could just forward a printout of the JIS just for clarification's sake, because I'm going to reference the fact that he's going to be supervised for 5 additional years with 8 years hanging over his head. Here we go. Thank you. Just wanted to correct that error. No comment as to charge 6 regarding the preponderance standard.
I'm going to take a moment before I announce my findings. In charge 1, reporting, I make a finding based on state's exhibits A and D. On charge 2, GPS, I make a finding based on state's exhibits A, D, E, and G. On charge 3, residence, I make a finding based on state's exhibits A, D, and E. On charge 4, absconder, I make a finding based on state's exhibits A and D. On charge 5, I make a finding based off Mr. Rodriguez's convictions, as well as A, D, and H through N. On charge 5, I make a finding, on charge 5 drugs, I make a finding based on state's exhibits A, D, and F. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, this is a situation where my client's been held 21 months. His PO only recommended a sanction of 6 to 9 months. This is his first violation of special parole. While incarcerated on the remand, I'd ask you to look at Exhibit 2. My client actually took actions to save the life of his cellmate. Due to his actions, he preserved the life of an inmate he was housed with. This is a letter from Captain Kalo, Exhibit 2, unsolicited from DOC. There was a letter sent to him back in July 26, 2023, which our client produced for us. Also, there's a certificate of his barber certification completion. My client is a single 36-year-old man. He receives his primary support from his mother, Maria Fuentes, his older brother, and he has 2 children, ages 11 and 10, who he is in contact with. He completed 1 year of college at Manchester Community College, studying health and exercise science. As I stated also, he has obtained his barber's license. He has a history of carpentry work, worked full-time at FHI for a few weeks until they did his background check. He had a barber position at City Styles Barbershop in Shelton. And while he has been remanded, unfortunately, the owner of that barbershop passed away. He participated in home renovations in Broadbrook. He was a half owner of Copper City Classic Barbershop in 2018, would work from 7 a.m. sometimes till 10 at night. He has an excellent work history. He's completed CBT group at New Haven AIC, the Explore program, outpatient at Connecticut Renaissance. He began domestic violence programming, and we have from his treatment provider, Cassandra Mastriani, client remained consistent with attendance and rendered urine drug screens when requested by the clinician. Client utilized treatment to discuss communication and relationships, both romantic and familial. He participated in anger management in from 2017 to 2019. He also was in relapse prevention at CRT, and he successfully completed in 2019 the App Foundation Residential Services Division program. As I stated, he saved his cellmate's life on Friday, June 9th, 2023, while held on remand. He painted murals in the gym. He was moved to a worker's block while at Walker and MacDougall. Upon reinstatement, he wishes to be sponsored again by his mother, and he's interested in enrolling in graphic design and working as maintenance and trainer back at FHI, which is now ABUSA. And he wishes to volunteer with his mother at convalescent homes. Like I said, although my client received a 2-year sentence, split sentence, he's been already held 21 months. We'd ask that he be released as soon as possible on that 10/24 review date. This is his first violation. The only misconducts he received were 2 for GPS violations that are part of this violation. Thank you for your time and consideration.
Counsel, you said this is Mr. Rodriguez's first violation of parole?
Special parole, from what we understand, yes, because he was released on 8/18/22 parole.
That was his last re-release.
Okay.
From our review of the case record, I have here that he was discharged of special parole originally in 2018. He's serving 10 years special parole.
Okay.
And this is his, let me see.
It wasn't referred to as being repetitive parole anywhere in the parole violation report. And because of that, we assume that it's his first.
Yeah. And so from review of the case record, this appears to be Mr. Rodriguez's 5th violation of parole.
Okay.
Yeah. 4th criminal and 5th violation. Mr. Rodriguez, I just want to confirm you were discharged to special parole originally in 2018. You're serving as
I didn't want to chime in because he was talking, but I was going to tell you after. Yeah, I left in 2018. I had a violation where they dismissed the case because they thought it was a DUI of blue zeros, but then I did have a DUI for driving. I was parked sleeping because I had a broken leg. I took some medication. I parked. But when they woke me up, they said I'm not supposed to be in the car in general. So I had that. I think I had a criminal trespassing before they got dropped to a breach of peace. I've had a few violations, misdemeanors, but yes, I've had a few violations.
Thank you.
Thank you for clarifying.
And in regards to, I just want to clarify, regarding the transcript, there was no evidence of a.
Yeah, there was a video.
Yeah, there's a video. So
They reviewed the video and they also looked at the scene, and there was absolutely no evidence whatsoever of a firearm.
But the video evidence does demonstrate that Mr. Rodriguez did fire a firearm, although there was no evidence of a firearm found, but there was a video evidence that he did fire a firearm.
No,
There's no evidence that he fired a firearm.
I was on the video prior of having a verbal discussion with the gentleman that filed the complaint, but something happened completely had nothing to do with me. And luckily the landlord, I didn't even know, the landlord gave a video to the court, not even to the police officers. And that cleared me because the girl that lived next door, that was my address.
Someone may have fired a firearm at some time. However, they found it found that, it says right here, this is from page 4 of the transcript, which one part was in the early morning hours, about 6:15 or so. And later on in the video, another individual who the neighbors allege was this individual came back and fired a shot. No gun was ever retrieved in document 918 and 820. That's a combination file. So that video, it says
they didn't add in there, but they arrested.
There was a Ring doorbell video which had 2 parts. And nothing in the transcript ever says that. It goes on to say one part was in the early morning hours, and later in the video, another individual who the neighbors may allege, but it's not in the video. There's no video of him shooting a gun whatsoever.
Because the person, I have it right here in the police report ending in 076, and I quote, video confirmed, I'm not going to say the victim's name, story as it shows Rodriguez point a gun in the direction of the driveway and fire 1 round before running from the scene to his vehicle and driving away in his black Honda. That's
and that's an allegation with absolutely no substantiation. And the state of Connecticut attorney Rebecca Berry didn't refer to that at all in her transcript. And the charges were essentially dismissed because they were substituted out and not pursued whatsoever. So I would contend that there's absolutely no evidence whatsoever, supportable evidence by a preponderance standard, that my client fired a gun or had a gun, because there is no gun.
Did I say something?
No, I would ask that you not say anything about any of the allegations about having a firearm, because I think it's clear that there is no proof and there's no substantiation by any court of law that there was evidence that you had a handgun or that you fired.
I know
it's just an allegation in a police report.
I completely understand that.
Okay, so with that caveat, sir, go ahead and say what you'd like to say.
Yes, they forgot to put that they arrested the other gentleman for having a weapon. So the other gentleman was arrested for having a weapon. My girlfriend also had a Ring camera, and she showed them the camera of him walking back and forth with a weapon in his hand. So he was arrested for that, not me. That's why the charges were initially dropped. That's why I got the harassment, because there is me on video and we had a verbal discussion, but everything else with the weapon was him, which he was arrested for. But
which is the second part of the video. They said there's 2 parts to the video, one early in the morning.
That's why it was dropped. So the thing was, his weapon was registered, so he had a registered weapon. That's why the whole confusion was with what they were going to charge me with, because the so-called victims were, which I didn't victimize anybody. I had a discussion with the gentleman. They wanted a criminal protective order. So in order to get a criminal protective order, they have to put a charge that deems it a domestic violence situation in order for them to put any kind of criminal protective order. So
because if you review, he was never arrested at all and never charged with harassment or any type of family violence crime whatsoever. It wasn't classified as a family violence case. They basically constructed a disposition in order so they could merely give him a protective order.
Yes.
So it's a fiction, essentially.
So I'm going to take a short recess before I announce my recommendation in terms of distinction.
Can I say something real quick before you do that? I
Sure.
wrote something to say real quick.
Okay, absolutely.
Many years of coming in and out of prison always made me feel stagnant. I've never had a progress or a progress report because in here, I've never made progress. My mindset was that I was frozen in time or that there's nothing to do in here. But again, waking up from the haze of a drug-induced mind-altering state and realizing it was back to square one, I was in prison again. I finally decided to really take a step forward in a place that I always felt that my feet were cemented in place. This time I worked and actually kept jobs. I used my talents and was able to do murals in 2 different prisons. And then I had a real eye-opener when I got a job in the infirmary hospice care unit in MacDougall. Even though it was just a bar position, I was able to come here, help, and also spend time with dying inmates and others with health conditions. It made me realize that this could be me one day, and I don't want that to be my future endgame. Through this all, I was trusted with all these opportunities by administration. Keyword trusted, and that was another step forward. For the first time, I didn't waste time in a place that I felt was a waste of time. I want to continue to move forward in these footsteps on the real platform where it counts in society and seek the rewards I found in a place I thought there weren't any. I can't explain my actions that landed me here, and excuse my language, but I'll be damned if I make excuses for my stupidity. Take full responsibility, feel shameful, foolish, selfish with my behavior and not thinking of others. I just thank God I'm alive after the accident and for my support system that still picks me up, even if it's from rock bottom, and that they believe in my intellect and potential for so much success. Through all this, I learned that God won't change the conditions for the man unless he changes the conditions within himself. And working on my inner self was something I put on hold for too long. But with a lot of with an act of compassion, if given the chance to show my improvement, I will work hard to not relapse, to focus on my family, my son most importantly, and myself.
Thank you.
Thank
So
you.
I'm going to take a short recess.
Yes, ma'am.
We now are back on record. So, Mr. Rodriguez, I have taken into consideration what your attorney has put on record, as well as your testimony. However, I have also taken into consideration that this is your 5th violation since being on parole. You have 4 of those 5 of these five violations. 4 of them are criminal, and per the review of the case record, they're all involve drug use as well, PCP use. Your current charges are very serious, and with that, I recommend revoke and reparole on July 17th, 2026, which is an approximate 3.5-year sanction. Your charges consist of assaulting a police officer and escaping from custody while at a hospital. So that is the basis for as well as the harassment second charges, as well as the following with the following conditions: no consumption of alcohol, domestic violence and anger management, no contact with victims FD, a general no contact with LB, JS, DS, and YT. In addition, you are to have no contact with AM without the express permission of your parole officer, halfway house placement in the event that it is needed, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on October 24th, 2024. Mr. Rodriguez, the panel may lessen my recommended sanction. My recommendation is not a final decision. The board may lessen it, or they can let my recommendation stand, or they can impose a sanction longer than what I have recommended. You have, if they accept what I recommended, you'll have approximately 2 years left on supervision. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be provided. Before the hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. During the supplemental hearing, you will have an opportunity to respond to those specific reasons while in front of a panel of the board. Do you have any questions?
What's the release date again? July what?
17th, July 17th, 2026.
What's your question, sir?
I do have a question. When I was sentenced, the statute never stated that I can receive time like that. I wasn't sentenced to suspended time. I was sentenced to.
You were sentenced to special parole.
I wasn't but I wasn't given the statute never stated that they can overexceed.
The statute says that if you receive special parole, and you receive 10 years of special parole, correct?
Yeah. Yes.
And if you violate that special parole during special parole,
that they couldn't sanction you up to more than 1 year.
That's not true, sir. That's a policy that's been changed.
Yeah, but how is that changed? When I received the sentence?
Okay, are you gonna let me answer your question or?
Yes.
Okay. So the parole board has the authority, and this is a recommendation it will go in front of the parole board. The parole board has the authority to completely revoke your parole based upon this violation and make you serve all of the time in jail.
When did they?
So that's a possibility.
When did they change that? When did they change that?
The 1 year policy that you're talking about only applies in the past. It doesn't apply anymore, but it only applied to technical violations, not new crimes.
Yeah,
it never applied, sir. It never applied to new crimes, and that was not a law. It was a policy of the former chief of the parole board. It's not a law, and that policy was changed. And that policy wouldn't have applied in your case anyway because you have a conviction. Okay? So they could have given you 5.5 years today.
Yeah, I know, I understand that.
But they gave you 3. He's recommending 3.5 years.
I took the sentence based on my attorney. I could have took 2.5 years flat with no probation or no suspended time.
Okay, so that, sir?
Yeah, but can I speak for a second?
I know exactly what you're saying.
Yeah,
you took the deal because you thought that the most they could give you here is a year.
Well, I want to get back to my son. Yeah,
right. I took lesser time. You never, ever in the time we talked said that the most that you never asked me whether or not the most you could get would be a year.
Yes, I did.
Never. We never had that discussion.
You told me that in June the statute changed, but that's why I'm asking How
Sir,
does that
I'm
apply
not
to
telling, I
me?
did not tell you, I told you that they could revoke your parole and hold you
know.
to the end of the period.
Yes, yes,
Okay,
you said that this.
I did say that.
You said the
Yes.
statute changed in June, but that's why I'm.
Policy change.
Yeah. I understand, but
Sir, everything that has happened today.
No, I understand.
Is legal.
Can you stop arguing with me, please? Can I speak to her? Thank
You
you.
can talk to her. I didn't realize.
I would like to speak to her.
Okay.
I understood that when I was sentenced in 2013, that I didn't know that if it changed, it would apply to me. So that means it's being run retroactive.
That's not true. That's not true, sir. This has always been the policy in parole, that if you violate parole.
They didn't explain that to me when I was sentenced.
Well, they don't necessarily have to explain that to you, sir. They don't. So what you should do is, once you go back and once they make their decision on the 24th, you should call me on the 25th. Then we'll actually know what your sanction is. And if in fact you relied on what your attorney told you in court as to why you should take the 2-year sentence instead of the 2.5-year sentence, you should call your attorney, Mr. Rudolph. Is that correct?
This wasn't.
Okay. This is the end of our hearing. So this is something this is a conversation we should have on the telephone. Okay?
Yeah, I don't want you to be my attorney anymore, though.
Well, but I'm not your attorney anymore.
I don't need someone arguing. Can you please just stop?
Okay, so this does conclude the hearing. So you will receive written notice from the board. In terms of what you do with counsel, that's up to you. But I am concluding the hearing at this time. Okay?
You'll hear from the board via the mail, sir.
Okay. Thank you.
You'll hear from the board.
Come on in, Sanders. You can head back, Rodriguez.
Good morning, Mr. Sanders. I'm going to just get your PO on the phone, okay? So we're going to get started in a moment.
Okay, thank you.
Good morning, Pio Lugo.
You may just need to press *6 to unmute.
Hello?
Yes, good morning. I just want to make sure you're able to hear me.
Yeah.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jarez Saunders 174-374. Today is Tuesday, September 15th, 2024. This hearing is being held via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Jarez Saunders 174-374.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Pio Lugo, as well as your attorney.
Attorney Robert Famiglietti of the Public Defender's Parole Revocation Unit. Hello, sir.
How you doing today?
Good, sir. How are you?
Right.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Sanders and Pio Lugo, please raise your right hand. Do you solemnly swear or solemnly affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you.
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officers bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state, your parole officers bringing against you, and the information underlying each charge. Pio Lugo, starting with charge 1, GPS.
Charge number 1, GPS. On 12/18/2023, you allowed your GPS unit to shut down from 11:46 p.m. until the following day, 12/19/23, when it cleared at 8:54 a.m., making your whereabouts in the community unknown. You violated a GPS agreement which states, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electric outlet for at least 2 hours each day. On 12/7/2023, you allowed your GPS to shut down at 7:03 a.m. until 8:57 a.m. On 12/13/23, you allowed your GPS to shut down at 4:52 a.m. until 9:18 a.m., making your whereabouts in the community unknown. You violated the GPS agreement, which states, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electric outlet for at least 2 hours each day. On 1/9/2024, you allowed your GPS unit to shut down at 9:31 p.m. until 10:28 p.m., making his whereabouts unknown in the community. Your actions violate GPS agreement, which states, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electric outlet for at least 2 hours each day. On 1/11/2024, you allowed your GPS unit to shut down at 11:24 p.m. and didn't clear until the following day, 1/12/24 at 12:34 a.m. On 1/12/2024, you allowed your GPS to shut down at 8:45 p.m. until 9:32 p.m. On 1/15/24, you allowed your GPS to shut down at 7:16 a.m. until 4:06 p.m., making your whereabouts unknown for approximately 11 hours. You actually violated the GPS agreement, which states, I am responsible to ensure the GPS tracking device remains charged for connecting the charging cable to the tracking device and plugging the charging cable into an electric outlet for at least 2 hours each day. On 4/29/24, you allowed your GPS to shut down at 2:47 a.m. until 6:11 a.m., making your whereabouts unknown. Your actions violate GPS agreement, which states, I am responsible to ensure GPS tracking device remain charged by connecting the charging cable to the tracking device and plugging the charging cable in an electric outlet for at least 2 hours each day. On 5/3/24, you allowed your GPS to shut down at 2:35 a.m. until 4:08 a.m. Your actions violated the GPS agreement, which states, I am responsible to ensure GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electric outlet for at least 2 hours each day.
Charge 2, obedience to the law.
Obedience to the law on 8/27/2024, you were found to be in possession of cocaine and marijuana by the CT State Police during a routine compliance check conducted at Watkinson Halfway House. K-9 conducted a search throughout the halfway house to include common areas and rooms. K-9 alerted behind a chair in the common area in which you were sitting in. Items were retrieved, and it appeared to be a white rock-like substance with multiple individual bags of marijuana. State police were dispatched, video footage was reviewed, and you were observed taking out a bag from your waistband and attempting to place it under the chair. The white substance was field tested and positive for cocaine. Subsequently, you were charged under Connecticut General Statute 218-279, possession of controlled substance.
Charge 3, halfway house placement.
On 8/3/2023, while the parole officer was conducting her tour at the halfway house, you were found in possession of smokable marijuana. Your actions violated the halfway house agreement, which states, I will not consume or possess alcohol or marijuana I will obtain this medication from an authorized dispensary in pill form only. Medical marijuana will be stored and disseminated by program staff consistent with all other prescribed medications. On 11/21/2023, you were issued a community pass to work. You left at 5:30 p.m. and returned at 7 a.m. On 11/22/23, you were issued a community pass to work, signed out from 5:30 p.m. and returned at 7:10 a.m. On 11/24/23, you were issued a community pass to work. You signed out at 5:07 p.m. You did not return until 7:15 a.m. On 11/27/23, you were issued a community pass to work and signed out at 5:30 p.m. and returned at 7:10 a.m. On 11/28/23, you were issued a community pass to work. You signed out at 5:30 p.m. returned at 8:30 a.m. On 11/29, you were issued a community pass to work, signed out at 11:30 p.m. and returned at 9:05 p.m. Your employer confirmed you never reported to work on 11/21/23, 11/22/23, 11/24/23, 11/27/23, 11/28/23, and 11/29/23. Your whereabouts were unknown throughout this time. Your actions violate the halfway house agreement, which states, I will not leave the physical confines of the halfway house or the property thereof, except for traveling to and from work or as authorized by facility or parole and community service division's rules. On 12/11/23, you were issued a community pass to work. You left at 5 p.m. from the halfway house, but failed to go directly to work. GPS confirmed you deviated to Vernon. On 12/23, you deviated from your community pass to work to a plaza in Manchester. On 12/13/23, you deviated from your community pass to work, and GPS confirmed you were at the Baymont at Wyndham at 6:30 p.m., Feinfeld at 6:45 p.m., and the plaza in Manchester at 7:25 p.m. On 12/14/23, at the plaza in Manchester 603, your actions violated the halfway house agreement, which states, I will only go to locations indicated on my approved community pass unless changes have been authorized by staff. On 1/17/24, staff witnessed you enter an unauthorized vehicle on the passenger side of and take off. You violate the halfway house residential handbook, where it states on page 23, please note DOC residents are not permitted to ride in any other person's vehicle without prior authorization from their case manager or DOC. You did not have authorization from this officer or halfway house staff. On 4/26/24, you were in the open hearth halfway house bathroom with an excessive amount of money that is not authorized in the halfway house. Your actions violate the halfway house agreement, which states, once I have obtained a source of income, I will save money and pay fees to the program as required. If I choose to open my own bank account, I will advise program staff. I understand that I do not need to provide my personal account information, but I must review the transactions history with program staff as requested to monitor my compliance. I will not have more than $50 in my possession without permission. If I need to withdraw a large sum of money, I will make this request in advance to program staff and or parole. On 8/27/24, you're found to be in possession of cocaine, marijuana by CT State Police during routine compliance checks conducted at Walkington Halfway House. K9 conducted a search throughout the halfway house to include common areas and rooms. K9 alerted behind a chair, the common area in which you were sitting in. Items were retrieved and appeared to be a white rock-like substance with multiple individual bags of marijuana. The actions violated the halfway house agreement, which states, I will not consume or possess alcohol or marijuana. I will obtain medication from an authorized dispensary in pill form only. Medical marijuana will be stored and disseminated by program staff consistent with all other prescribed medications.
The state has filed the following exhibits, starting with Exhibit A.
Connecticut Department of Corrections remand to actual custody order. E, State of Connecticut Board of Pardons and Parole Conditions of Parole. Exhibit C, Notice of Parole Violation. Exhibit D, Parole Violation Report. Exhibit E, Misdemeanor Summons and Complaint. Exhibit F, Criminal Appearance Bond and Notice of Rights. Exhibit G, State of Connecticut Department of Public Safety Investigation Report. Exhibit H, Halfway House Agreement from Open Hearth and Watkinson. Exhibit I, GPS Monitoring Agreement. Exhibit J, Offenders Misconduct. Exhibit K, the Open Hearth Behavioral Contract, 8/3/23. Exhibit L, Offenders Misconduct. Exhibit M, the Open Hearth Incident Report for 11/30/23 and 12/5/23. Exhibit N, Offenders Misconduct. Exhibit O, Allied Universal for 12/18/23 to 12/20/23. Exhibit P, Offenders Misconduct Report. Exhibit Q, Allied Universal 12/5/23 till 12/15/23. Exhibit R, Allied Universal Position History. Exhibit S, Allied Universal View Offender. Exhibit T, the Open Hearth Incident Report for 1/18/24. Exhibit U, offenders misconduct. Exhibit V, allied universal event history from 1/5/24 to 1/12/24. Exhibit W, allied universal event history from 1/11/24 to 1/15/24. Exhibit K, the Open Hearth Resident Handbook. Exhibit Y, offenders misconduct report. Exhibit Z, allied universal event history from 4/26/24 to 5/3/24. Exhibit AA, State of Connecticut Judicial Branch pending case details. Exhibit B, Open Hearth Incident Report. Exhibit C, images and videos. Exhibit D, Community Solutions Incorporation Walkerton Remand Report.
The state has filed an addendum to Exhibit D, which states on September 19th, 2024, Mr. Saunders was sentenced to unconditional discharge for possession of controlled substance first offense under docket ending in 932. Counsel, did you receive the notice of parole violation, report, and the other documents that were just marked for identification purposes?
Yes, I have.
Okay. Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses, and at this time, the state will have an opportunity to present evidence to speak to any of the evidence submitted. P.O. Lugo?
So I kind of wanted to speak on the evidence that was presented from Saunders regarding the successful discharge from Renaissance East and then sponsoring to the sponsor. When he sponsored to Keith Cheney, he was under supervision with Parole Officer Pham, and at that time, Mr. Saunders was found with multiple websites of pornography, noting to that I've noted in the recommendation, which was offense related with angry father enters his daughter's room, and a lot of rape of his, considering the rape of his adolescent daughter. So he was placed at the January Center due to those circumstances. And during his stay at the Reach Requirement, Mr. Saunders did nothing to advance or to be able to discharge out of the program successfully, and that's why he was moved to the Open Hearth Halfway House.
Anything further regarding the evidence and the evidence submitted?
Mr. Saunders was found with the crack cocaine at Walkerton Halfway House. We had some suspicions that he was doing the same thing at Open Hearth, but there wasn't any incident that we could actually verify this information. And then when Mr. Saunders was moved to the Walkerton Halfway House, it was kind of confirmation to the situation. I asked staff, Program Director Elijah, and I spoke to Case Manager Kevin regarding the excessive amount of cash. They were unaware. They have no idea of how Mr. Saunders was able to obtain such an excessive amount of money, and that they were actually surprised that the image was taken in their halfway house bathroom.
Anything further?
No, ma'am.
Okay. It is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Much of what was just said, I think, is irrelevant. And the fact that my client may have had what someone may have thought was an excessive amount of money is irrelevant and not a violation of his parole. He could have a wealthy family. He could have inherited the money. It's not a basis. It's not a negative, and it certainly isn't a basis or a reason to give him any more parole time or not parole time. It's irrelevant. We have an individual. As to the charges now, we're speaking about the charges first. Yeah, that's what I thought. I have no comment as to charge 1 regarding the preponderance, no comment as to charge 2 regarding the preponderance. There is some allegation in charge 3 that he had an excessive amount of money. I don't think there's any element or basis of violating parole for that. What is excessive? I think that's a slippery slope argument. It's a relative and subjective determination. So I don't believe that any of that evidence should be considered. Thank you.
We did include it. Oh, I'm
I was
so
gonna-
sorry.
No, I was gonna ask you if there's anything else you want to say regarding the charges.
So the image, I provided a picture that was found in Saunders' phone of him with the excessive amount of money, which is actually in the third floor bathroom of the halfway house, which he would have had to pass, check in with staff at the front desk and everything to be able to even get to the third floor bathroom with that amount of money.
Sir, don't even answer that.
There's an image.
I don't care if there's a movie about it. Right. It's irrelevant, and it's not a violation of his parole. And whether or not he had it in the bathroom, on a plane, on a train, in a box with a box, it's irrelevant. Thank you.
Lugo, anything further before I announce my findings?
No.
Counsel, anything further?
That is to the findings.
Okay. I'm just gonna take a moment before I announce my findings. On charge 1, GPS, I make a finding based on state's exhibits B, D, I, N, O, P, Q, V, W, Y, and Z. On charge 2, obedience to the law, I make a finding based off of Mr. Sanders' conviction as well as state's exhibits B, D, E, F, G, C, C, D, D, and H, H. On charge 3, halfway house placement, I make a no finding on part 5 as the state failed to provide sufficient evidence to prove that Mr. Sanders' actions meet the elements of this charge. I make a finding on the rest of the parts listed in this charge based on state's exhibits B, D, E, H, J through N, P through T, C, C, and D, D. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Do you wish to make a statement regarding Mr. Sanders' background and history at this time?
I do. If we could please refer to my recommendation and his inconsistency in the community, his inability to properly adjust, his inability to follow directions, as all stated in the recommendation, the threat statement that he made to Officer Pham, which she's willing to speak on regarding this, that I'm recommending no less than a year, if not revoked.
Counsel, do you wish to make a statement regarding Mr. Sanders' background and history at this time?
I do. Just before I make any statements, I just want to assure that he was paroled on March 12th of 2021, correct?
His re-parole date or his actual discharge?
When he started this period of special parole that we're talking about here, 3/12/21. 3 years ago.
Are you asking me this?
No, I'm looking into it. I'm looking at. So you're saying what date?
3/12/21 is what I was told.
No, he was discharged on December 29th, 2020 to special parole.
2020?
Yeah.
So longer. Okay. December 29th, 2020?
Yes.
Okay. And is this his first violation?
Yes.
Yes, then this is his first violation. Thank you. So we have no violations in 2000 and the 2 days in 2020. We have no violations in 2021. We have no violations in 2022. And then we have one all the way into August that he had marijuana. And then nothing until November, the end of November, when his brother was murdered 2 days before Thanksgiving. So that's a change in circumstances. That's a stressful change in circumstances. His brother is murdered. So we have 11/21, 11/22, 11/24, 11/27, 11/28, 11/29, never reported to work. His brother was just murdered. 12/11, 12/12, 12/13, 12/14, diverting from past. All of this conduct after almost 4 years of no problems. The disobeying of the law was August of 2024. He's been on parole since December of 29th of 2020. And he gets arrested for possessing cocaine. Not a violent crime. It's him trying to cope with his problems. There's no treatment violations here. There's no behavioral treatment plan violations here. There's no statements here that he didn't go through treatment. Was he referred to treatment? That's a question. I don't know. But if he was, there's actually nothing here. The recommendation is for a year, quote unquote, to establish mental health services in the facility. What mental health services is my client going to get in a jail cell? Nothing to reflect. It's purely punitive. My client was on parole, nonviolent. We're talking about his GPS during this entire time, starting on December 18th, after his brother was murdered, down 9 hours, down 2 hours, down 5. This is not a reason to incarcerate someone for a lengthy period of time. Diverting from past, having an excessive amount of money. I know you didn't find that. I think it's interesting to know, is this, sir? Sir, can I ask you a question, sir?
Yes.
Is this the PO that you referred to that was a CO in your unit at MacDougall for 3 years? That's
Yes.
speaking today?
Yes.
So my client asked for a new PO a long time ago. And this PO was a CO for over 3 years when he was at MacDougall in the same unit. I contest that's a conflict of interest. His brother was murdered. He was working third shift for the GPS violations at FHA in Manchester, and he couldn't charge him. Nothing here is violent. It's his first violation, and he's been out since 2020. My client is a single 52-year-old man. He receives support from his half-brother, Keith Cheney, who's a truck driver. He has lost all of his immediate family members as they have passed away. He is the only one living out of approximately 13 family members. This is a significant amount of trauma, and then this was all precipitated when he lost his brother 2 days before Thanksgiving. He completed 3 semesters in the machine engineering program through Quinebaug Valley Community College in Danielson in the past. It was stopped due to the COVID-19 pandemic. Most recently, while in the community, he worked with CPA at 22 Sargent Street in Hartford. He reportedly received various licenses, including his driver's license, scaffold, 3-port harness restraint, drywall, industrial construction, MOOP operator, and OSHA 10. He has also applied for drywall school through District 11 United Allied Painters and Associates. He was working in the past full-time at CNC as a machine operator in Watertown, full-time at Walgreens Distribution Center in Windsor. Most recently, full-time third shift where he couldn't charge his battery at FHI located at 1315 Tolland Turnpike in Manchester. He was working 12-hour shifts for approximately 7 months before his remand. While he opened Hearth, he was attending AA and NA meetings. There was a reflections group in the morning and a substance abuse with 12-step programming. He participated in the Connection Center for the Treatment of Problem Sexual Behavior. There's no allegations in this violation that he's done anything wrong regarding any sexual behavior. And any reference to it, I think, is irrelevant. He participated in outpatient services, including individual therapy and medication management at Wheeler Clinic. He volunteered at Food Share every Thursday for about 2 hours, beginning at 4:03 a.m. through Bishop Donald Johnson. Upon reinstatement of special parole, he's amenable to being placed in a halfway house in Hartford or perhaps Middletown as a backup. Eventually, he'd like to obtain independent housing or utilize a sober house. He's been in contact with a landlord named Elvis who rents rooms in Hartford and East Hartford. He wishes to enroll and complete the machine engineering program at Goodwood University. He tried to enroll, but it was already full. He also wishes to enroll in tractor training school and obtain his CDL. And he wishes to apply to the previous FHI where he was working at the third shift. It's now ADUSA. Client is nonviolent. He hasn't harmed anyone. He was devastated by the loss of his brother. I don't see any reason to further incarcerate him. It's his first violation. He's been held since August 27th, approximately 2 months. Any insinuation that he should be or totally revoked, to me, is draconian. Thank you.
Pio Lugo, anything further before I announce my recommendation?
Yes, regarding him being out in the community since 2020, he was taken back to the January Center due, as I stated before, due to the excessive amount of pornography that was on his phone, and it was offense related. During that time, there wasn't much violations. When it comes to the brother, he was working third shift, so he was unaccounted for the late hours of the night, 1 a.m., 2 a.m. Don't know what support he would have provided for his family at that time. And considering he has a no minor stipulations, we are unaware if he had any contact with minors during that time. Drug screenings aren't there because Mr. Saunders doesn't use crack cocaine. He's never tested positive, not once, and we've had him on weekly testing. When it comes to the correctional officer comments, which I think is irrelevant because I am a parole officer now, I was an officer for a little over a year at MacDougall Walker. So it's impossible that he was in my unit for 3 years. And I don't even recall him being in my unit for that long, or even in my unit at all.
He can't hear. Sir, can you hear?
When it comes to the GPS, when it comes to the GPS unit, we have multiple offenders that are on third shift. And we've never had an issue with them charging during the day when they wake up and are going about their daily business. No issues with them charging the unit whatsoever. And considering the fact of the level of his offenses and his unaccountability on third shift and his no contact with minors, it is very concerning for the safety of the community in that sense. He may not have harmed anybody at this time, but are we going to wait for the situation to occur?
I took a lie detector test.
Let me answer that, sir.
Counsel, do you have any?
There's no allegation here that my client in any way, shape, or form had any contact with minors, intends to have any contact with minors.
Well, let's say,
No.
Pio Lugo, you'll have another opportunity to speak.
Okay, all right.
There's absolutely no evidence, zero, presented in this violation in any of the exhibits that my client had any contact or intends to have any contact with minors, period. To insinuate that we don't know what could happen there, we're going to wait for something to happen. That is terrible. That's not the way we should think about human beings. We're going to lock does that mean we lock people up because they might commit crimes in the future? The whole purpose and of the Board of Pardons and Paroles is the successful reintegration of appropriate people back into the community. Reintegration back in the community, not warehousing them in jail. This is my client's first violation of parole. He was on parole for 4 years. Even if everything in charge 1, 2, and 3 is true, and he has no excuse, a year is way too long for this violation and for these bases. Thank you.
Pio Lugo? Anything further?
Yes, I'm sorry. So kind of piggybacking on the successful and being reintegration successfully into the community. That is definitely our goal. But considering the fact that he's been out since 2020, we have all of these charges, and there was additional charges, but it's past our time frame to add them. Mr. Saunders has proven he's done absolutely nothing to be successful in the community at this time. And Mr. Saunders has failed multiple polygraphs when he was out in the REACH program out in the community. The only time he just passed the polygraph is because he was in a halfway house and had limited movement. So, and I never saw proof of him volunteering at a church where minors are distributing meals for the homeless. Not once have I received proof of that or
Hello? Go ahead.
Yeah. Regarding the situation. So all the polygraphs when Mr. Saunders was in the community, living at his brother's house and living in the REACH program, he did not pass. It was only until he was at Open Hearts and was there for over 6 months and they administered that polygraph exam is when he passed.
Do you think that's, I just want to ask a question. If you think that's important, and if he's such a risk to the community and minors in the community, don't you think that would have been important to include as a basis of a violation in his report?
I can't include treatment.
Then why are you referring to it? It's irrelevant. You brought it up. I have no further comment.
You stated that he passed his polygraph. I was just confirming the information that you provided.
I never said he passed the polygraph.
You'll go anything further before I announce my recommendation?
No, ma'am.
No,
I have nothing further.
And Mr. Sanders, you was raising your hand to say something.
What do you want to say, sir?
I just want to say, I passed the polygraph referring to all those GPS failures. The GPS was dying while I was asleep at the halfway house, not when I was at work. Check them out. You could call Bishop Donald Johnson to verify I was doing food share while I was in the REACH apartment on Standish Street where I lived at. I was going over there, taking my time out every week to do food share. I couldn't remember whether it was 3 years or a year I was in the unit with that officer at MacDougall. And she gave me a polygraph and she added questions about the absconding to Vernon. She said I was in a hotel. I passed the polygraph in April and was graduated out of the sex offender treatment group. I have no children on my mind.
Thank you, sir.
Just to confirm, Pohl Lugo, nothing further?
Nothing further.
And Council, I'm going to take a moment before I announce my recommendation. Mr. Sanders was in the community for about over 3.5 years. He did receive a number of GPS violations and was found in possession of cocaine. Based off of all the evidence provided and the testimony provided today, I recommend revoke and reparole on January 27, 2025, which is an approximate 5-month sanction with the following conditions: no contact with victim ZS or the mother of the victim, halfway house placement, no contact with minors without the express permission of your parole officer, mental health evaluation, and problem sexual behavior treatment. My findings and recommendations will be forwarded to the board. You will receive the official written decision from the board, and your board review is scheduled on October 24th, 2024. The board may lessen my recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be held. Before that hearing, the board will provide you with written notice documenting the reasons why they might want to exceed my recommendation. During the supplemental hearing, you will have an opportunity to respond to those specific reasons while in front of a panel of the board. Okay, Mr. Sanders, so my recommendation is January 27th, 2025. The board will review your case and make the final decision on October 24th, 2024.
So, sir, you can call me on the 25th. Call our office on the 25th, and we will tell you what the board decided. Okay, sir?
Thank you.
You have a nice day, sir.
Can I have the phone number?
I will call. Okay, I can. Your corrections counselor will have our phone number. Okay, sir. All right,
Yes.
we're the parole public defenders in Waterbury. Okay.
Thank you.
You're welcome, sir. Have a nice day.
You too.
Thank you, P.O. Lugo. Thank you.
Thank you.
This thing's muted here.
Good afternoon, Mr. Markey.
Good morning.
My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is the revocation hearing concerning Michael Markey, 390-805. Today is Tuesday, October 15th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Corrigan Correctional Institution. Please state your full name and DOC inmate number for the record.
Michael C. Markey, inmate number 390-805.
This is a public hearing. Public access to this hearing is available via video live stream. Present this afternoon is your attorney.
Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
Good morning to you too, sir.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Markey, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you very much. First, I will read you your rights. Then we will review the parole violation charge that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
Pardon me?
Do you have any questions or do you have any questions? Okay. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state your officer is bringing against you and the information underlying each charge. On charge 1, program participation, a no finding was held at the preliminary hearing held on August 13th, 2024, and will not be considered at today's revocation hearing. Charge 2, enhanced internet and device monitoring. On July 8th, 2024, you were found to be in possession of an unauthorized tablet that staff from the Eddy Center and your parole officer were not aware of. You continue to ignore a direct order given by staff and parole to provide your security code. After multiple direct orders, you provided the code and a preliminary search was conducted. You were in possession of multiple sexual images and videos of men and women. Your search browser consisted of multiple sexual illicit websites such as xhamster.com, free black amateur porn, deviantart.com, spankbank.com, txxxx.com, and shesfreaky.com. Due to being in possession of an unauthorized device, the possession of multiple explicit images, and the use of explicit pornography websites, you were issued a misconduct and placed in the January Center for Inpatient Problem Sexual Behavior Treatment. Charge 3, restriction on pornography. On July 8th, 2024, you were found to be in possession of pornography material on an unauthorized tablet while at the Eddy Center, and on July 25th, 2024, 2 pornography photo images while at the Inpatient Problem Sexual Behavior Treatment Program January Center. Following the seizure of your tablet, the Computer Crimes and Electronic Evidence Unit were able to identify that you had thousands of pornography images and still photos on the tablet. The Computer Crime Unit supplied Parole with the report listing of multiple websites that you found to be searching that consisted of xhamster.com, Free Black Amateur Porn, DeviantArt.com, SpankBig.com, TXXX.com, and She'sFreaky.com. On charge 4, from sexual behavior treatment, a no finding was made at the preliminary hearing held on August 13, 2024, and will not be considered at today's revocation hearing. The exhibits that were marked and identified at the preliminary hearing held on August 13, 2024. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, I have.
Defense has filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Yes, we're going to charge 2 and 3. It's essentially the same factual basis. There's no proof. In fact, there's proof contrary to the fact that this is my client's tablet. This is a tablet that was available at the Eddy Center. It wasn't his search engine. He didn't have exclusive possession, control, or access to this tablet. This was a tablet that more than one person possessed. There's no proof offered as to when, how, why, or whom downloaded or visited any sites. You can pick up my cell phone, which is essentially a tablet, and go and see the history, but it doesn't show who visited it. It doesn't show who was in possession when they were accessed it. He may have been the last person holding this tablet, but that's like a game of hot potato. Just because you're the last person caught with it means that they're your images, means that you're the one that searched the engine, means that you're the one who possessed. There's absolutely no proof that he ever accessed those images or saw those images. So I don't believe it meets the preponderance standard as to knowledge, as to access, as to whether or not he is the actual actor or owner or controller or accessor of any of this information. Thank you.
On charge 2, enhance internet and device monitoring, I make a finding based on state's exhibits A, D, E, F, and G. On charge 3, restriction on pornography, I make a finding based on state's exhibits A, D, E, F, and G. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes. The client is a divorced 61-year-old gentleman. He served in the United States Navy for 14 years. And was honorably discharged. 3 of those years, he was a police officer in the Navy at the sub base in Groton, Connecticut, guarding our subs. He receives his primary support from his mother, Shirley Johnson, his brother, Richard, and sister, Jennifer. They all reside in Connecticut. However, his adult sons reside in Mississippi. He wishes to return there once his sentence is over to fish with them and live out the remainder of his days with his family. He was last employed in 2011 as a home health aide at a retirement community, and he's on 10% military disability. He wishes to engage himself with treatment at the Veterans Hospital and through Veterans Affairs. He has in the past from 2011 to 2012 and in 2018 in West Haven. He participated in CTPSB treatment. There's absolutely no allegation that he was non-compliant in any way, shape, or form with any of that treatment. He has a history of diabetes. And while at the Ed Center, he contracted influenza and pneumonia. He meets with his medical unit regularly and daily while incarcerated for his medical conditions. He wishes to be placed in a halfway house in either Waterbury or secondarily in Bridgeport. He wishes to apply for a disability. I don't believe any of these allegations are violent whatsoever. I don't believe he's a threat to the community. I don't believe that the state can prove that actually he had exclusive possession and access to this information. He wishes to return to Mississippi. He suffers from PTSD, and while in placement, he suffered from a stroke. He is in a wheelchair and is suffering from diabetes. I see no reason to give him a lengthy sanction. His max date is May 26, 2025. I believe, is that correct? And we hope that he not be revoked. We hope that he's monitored in the community prior to the end of his sentence. Thank you for your time and consideration.
I'm just going to take a moment before I announce my recommendation. Yes, counsel, his end of sentence is May 14th, 2025.
May 14th.
Right.
Oh, okay. I thought it was the 25th. Thank you.
Right after my birthday.
I recommend revoke and reparole on December 9th, 2024, which is an approximate 4.5 month sanction with the following conditions: enhanced internet and device monitoring, halfway house placement, mental health evaluation, no contact with minors without the express permission of your parole officer, problem sexual behavior treatment, and restriction of pornography. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board. Your board review is scheduled on October 24th, 2024. The board may lessen my recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing would be held before the hearing to provide you with written notice outlining the specific reasons why they might want to exceed my recommendation. During the supplemental hearing, you will have an opportunity to respond to those specific reasons while in front of a panel of the board. So this does conclude the revocation hearing. Do you have any questions?
No, ma'am.
Okay,
You
thank you
say
very
you
much.
recommend a 4-month stay here?
A 4.5 month, yep. So my recommendation
Total?
Total, yep, a reparole on December 9th, 2024, which will be about
December
4.5
9th?
months. Yeah, but
Will
the
be
board
my
has
last day,
the,
right?
well, the board has the final decision. They're going to make the final, they're going to make the decision
It's up
on
to the board, sir. They'll make their decision on the 24th.
Mhm.
Call our office on the 25th and we'll let you know what they decided, okay?
Yes, sir.
You're welcome. Have a good day.
You too. Thank you.
Thank you. You're welcome.
Good morning.
Good morning, P.O. Goodman, or good afternoon.
Oh, yeah, it is. Good afternoon. Hi, Mr. Famiglietti.
Oh, P.O. Goodman.
How are you?
Oh, just stuck.
These short weeks are hard.
Not as bad as the long one.
Attorney Jones, my apologies. I was trying to disconnect the facility and I clicked your name.
Oh, okay. No worries. I just was like, oh, maybe they need me for something. No worries.
Good afternoon.
Hey, how you doing?
Good. We only have Mr. Saunders with you today.
Yep. Come in. That's the only gentleman you need to see, right?
Correct.
Gotcha.
Good afternoon. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jesquan Saunders, 397-044. Today is Tuesday, October 15th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in New Haven Correctional Center. Please state your full name and DOC inmate number for the record.
Denelle Saunders, 397-044.
This is a public hearing. Public access to this hearing is available via video live stream. Present this afternoon is P.O. Goodman, as well as your attorney.
Attorney Robert Famiglietti of the Parole Revocation Unit of the Public Defender's Office.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of your conditions of parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony of today's hearing will be taken under oath. Mr. Saunders and P.O. Goodman, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I will now agree with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your officer is bringing against you and the information underlying each charge. P.O. Goodman, starting with charge 1, obedience to the law.
Sure. On or about 4/1/24, Waterbury police were dispatched to a residence in Waterbury on a domestic disturbance where a female victim reported you threatened to kill her. She reported you took her belongings, including her apartment keys, and refused to give them back. She reported you had threatened to shoot her 2 to 3 weeks prior to the incident. Based on the circumstances and in accordance with CT law and police policy, Waterbury police applied for an arrest warrant, which was subsequently approved by the court for the charges of threatening second and breach of peace second. On 7/24/24, you were arraigned in GA4 under docket number U04WCR24-0510029-S, threatening second and breach of peace second. At the time of your arraignment, probable cause was established. On or about 4/30/24, Waterbury police were dispatched to a residence in Waterbury on a domestic complaint. The female victim reported you got into an argument that got physical. She reported you punched her in the face with a closed fist multiple times, causing a cut on her lip. She also stated that you caused pain in her left arm by pulling her into a hallway in order to continue to hit her, causing scratches and bruising on her arm. She reported you broke her television by kicking the screen. She reported she fears for her safety, and your constant texting and calling causes alarm and annoyance. Based on the circumstances and in accordance with CT law and police policy, Waterbury police applied for an arrest warrant, which subsequently was approved by the court for the charges of assault third, harassment second, and criminal mischief third. On 7/24/24, you were arraigned in GA4 under docket U04W CR24-0510028-S, assault third, harassment second, and criminal mischief third. At the time of your arraignment, probable cause was established.
Charge 2, drugs.
On 4/11/24, you tested positive for cocaine on an instant test cup. The test cup was sent to Career Biotech Labs for confirmation, and the positive result was confirmed. As a result, you were in violation of release direction, obey all laws.
Charge 3, travel.
On 4/1/24, you left the state of Connecticut without prior written permission from your parole officer. You were stopped by New York Police Department, at which time your name was run in NCIC. You initially denied leaving the state and police contact, but when confronted with the NCIC supervised person hit, you admitted going to the city and that you were pulled over by the New York Police Department as the tints on the vehicle were too dark. As a result of your behavior, you are in violation. Release direction travel.
The state exhibits were marked and identified at the preliminary hearing held on August 13th, 2024. The state filed an addendum to Exhibit D, which states on September 12th, 2024, Mr. Saunders appeared in Waterbury Superior Court, GA4, under docket ending in 028. He pled guilty to assault third and was sentenced to 3 months. The charges of harassment second and criminal mischief were nollied. On the same date, he appeared in Waterbury Superior Court, GA4, under docket ending in 029. He pled guilty to breach of peace second and was sentenced to 3 months concurrent to docket ending in 028. The threatening second charge was nollied. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, I have.
The defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses. At this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted. Peel Goodman?
Hi, thank you. I think the charges speak for themselves, so I'm not going to belabor the point by going on with talking about the charges.
Counsel, it is now your opportunity to present evidence and speak to any of the evidence submitted.
Yes, regarding the charges, I have no comment as to the preponderance standard.
On charge 1, obedience to the law, I make a finding based on Mr. Saunders' conviction, as well as states exhibits A through D, or A and D through I. On charge 2, drugs, I make a finding based on states exhibits A, D, and K. On charge 3, travel, I make a finding based on states exhibits A, D, and J. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Peel Goodman, do you wish to make a statement regarding Mr. Saunders' background and history at this time?
Mr. Saunders has been supervising the community since approximately 2021. He has struggled a little bit with substance use. This is, I believe, his third arrest. While he's been under some sort of supervision, whether it is discretionary or special, the state is recommending a 9-month sanction as a result of the new charges, especially because they are violent in nature. Mr. Saunders is required to register with the Deadly Weapon Offender Registry. So there's past history of possession of guns and drugs in his past. And like I said, in the recommendation, we're just looking for a 9-month sanction.
Counsel, do you wish to make a statement regarding Mr. Saunders' background and history?
I think someone else is speaking, not my client. I just think that's background noise. Yes, my client, Mr. Saunders, is a single 29-year-old man. He receives support through his father, mother, sister, paternal aunt, as well as his fiance. He has 2 daughters, ages 12 and 9, and he's also expecting a 3rd child. His fiance is. My client was employed full-time at Bazzuto's in the past, previously. Most recently, he reported he established a clothing line, Stick to It, and he sold merchandise for approximately 7 months, clothing. He was on a maximum contact schedule with a good regularity of contact. He obtained his driver's permit while in the community. Upon reinstatement, he'd like to be sponsored by his mother, Margaret Eccles, in Waterbury. We have her information in our report. He also wishes to enroll in tractor trailer training school and obtain his CDLA. His sentence is fully up on 10/22/24 to the best of my knowledge. His sentence ends in 2030. He had misconducts. However, we believe those were addressed in the community. He did receive a punishment, he says, for being stopped in New York. He was paroled. I believe his last parole was 6/27/23. And then these violations all occur within a 1-month period in April of 2024, occurring on 4/1, 430, 411, and 41. We would ask that he be immediately released to the supervision of parole, as we believe the nature of these violations aren't so serious enough to warrant further incarceration. We don't believe further confinement is necessary or appropriate. He's been held for approximately 3 months now. I don't believe that there's any reason to hold him at this point in time. He has served his time for these incidents. Thank you for your time and consideration.
P.O. Saunders, the one thing I did forget to add and put on the record that while he was awaiting adjudication on the current charges, he did get a Class A DR for fighting in August, and I believe I submitted that via addendum as well. So it kind of speaks to a pattern of violent behavior.
Counsel?
I don't know any of the facts or surrounding circumstances. We don't know who started the fight. It obviously takes two to tango.
They started it.
I know we none of that information is here. He received 5 days in segregation. He has served that time. I have nothing more to say about that. Thank you.
Okay. P.O. Goodman, anything further?
No, ma'am. Thank you, guys.
And P.O.
Nothing further.
Okay. Please take a moment before I announce my recommendation. I recommend revoke and re-parole on January 24th, 2025, which is an approximate 6-month sanction with the following conditions: no consumption of alcohol, halfway house placement, and mental health evaluation. My findings and recommendation will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on October 24th, 2024. The board may lessen my recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be held. Before the hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. During the supplemental hearing, you would have an opportunity to respond to those specific reasons while in front of the panel of the board. That does conclude the revocation hearing. Mr. Saunders, do you have any questions?
I didn't hear the dates that you said. I'm sorry.
Okay. I recommended a 6-month sanction with a re-parole date on January 24th, 2025.
Okay.
So the final decision, sir, will be up to the board, okay? And they will make their decision on the 24th of this month. So call us on the next day and we'll let you know what happened, okay?
Okay.
All right, have a great day.
It was well.
Take care.
Thank you.
You're welcome.
Thank you.
Thank you.
Take care.
Bye, Jesquan. Have a great afternoon, guys. Thanks.